define the following terms. Jus cogens. Jus cogens is a peremptory or absolute norm of general international law, accepted and recognized by the international community as a whole, as a norm from which no derogation is permitted and which can be modified only by a subsequent norm of general international law having the same character. Principle of double criminality. Under the double criminality rule, the extraditable offense must be criminal under the laws of both the requesting and the requested states. This simply means that the requested state comes under no obligation to surrender the person if its laws do not regard the conduct covered by the request for extradition as criminal. Act of State Doctrine. Under this doctrine, courts of one country will not sit in judgment on the acts of the government of another in due deference to the independence of sovereignty of every sovereign state. Precautionary Principle. Under this principle, in order to protect the environment, the precautionary approach shall be widely applied by states according to their capabilities. Where there are threats of serious or irreversible damage, lack of full scientific certainty shall not be used as a reason for postponing cost-effective measure to prevent environmental degradation. Under the United Nations Convention on the Law of the Sea, or UNCLOS, what are the rights of the Philippines within the following areas? Contiguous zone. Within the contiguous zone, the coastal state may exercise control necessary to 1. Prevent infringement of its custom, fiscal, immigration, or sanitary laws and regulations within its territory or territorial sea, and 2. Punish infringement of the above laws and regulations committed within its territory or territorial sea. Exclusive Economic Zone. Within the exclusive economic zone, the coastal state has 1. Sovereign rights for the purpose of exploring and exploiting, conserving and managing the natural resources, whether living or non-living, of the waters superadjacent to the seabed, and of the seabed and its subsoil, and with regard to other activities for the economic exploitation and exploration of the zone, such as the production of energy from the water, currents, and winds. Number 2. Jurisdiction as provided for in the relevant provisions of this convention with regard to a. The establishment and use of artificial islands, installation and structures. B. Marine scientific research. C. The protection and preservation of the marine environment. And D. Other rights and duties provided for in this convention. Article 56, UN Clause. The Humanitarian Services Society, HSS, an international non-government organization, assisted the displaced families of Tribe X who had to flee their home country in order to escape the systematic persecution conducted against them by their country's ruling regime based on their cultural and religious beliefs. Fearing for their lives, some of these displaced families, with the help of HSS, were able to sail out into the sea on a boat, which eventually landed in Palawan. The Philippine Coast Guard intended to push back the boat with 15 passengers. An affiliate of HSS in the Philippines intervened on behalf of these displaced families, claiming that they are refugees under international law and hence should not be expelled from our territory. May the displaced families of Tribe X be considered refugees under the international law? Answer: yes, because under the 1951 Convention relating to the status of refugees, to which the Philippines is a signatory, a refugee includes one who, as a result of events and owing to well founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion, is outside the country of his nationality and is unable, or owing to such fear, is unwilling to avail himself of the protection of the country. Mrs. W. supplies the Philippines National Police with uniforms every year. Last month, he and two other officers of the PNP conspired to execute a ghost purchase covered by 5 checks amounting to 200,000 pesos each, or a total of 1 million. An investigating committee within the PNP, which was constituted to look into it, invited Mrs. W., among others, for an inquiry regarding the anomalous transaction. Mrs. W. accepted the invitation, but during the committee hearing, she stated that she will not answer any question unless she be provided with the assistance of a counsel. The PNP officials denied her request, hence, she no longer participated in the investigation. What is a custodial investigation? Under the 1987 Constitution, what are the rights of a person during custodial investigation? Answer: custodial investigation is the stage where an investigation ceases to be a general inquiry into an unsolved crime, and direction is then aimed upon a particular suspect who has been taken into custody and to whom the police would then direct interrogatory questions which tend to elicit incriminating statements. People versus La Cruz. Custodial investigation also include the practice of issuing an invitation to a person who is investigated in connection with an offense he is suspected to have committed, without prejudice to the liability of the inviting officer for any violation of law. RA 7438. A person under custodial investigation has the following rights, to wit: 1. To remain silent. 2. To have competent and independent counsel, preferably of his own choice, and if he cannot afford the services of counsel, he must be provided with one. 3. To be informed of such rights. 4. Waiver of these rights not allowed except in writing and in the presence of counsel. 5. No torture, force, violence, threat, intimidation, or any other means which vitiate the free will can be used against him. 6. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. And 7. Any confession or admission obtained in violation of these rights are inadmissible in evidence against him. Q. At about 5:30 a.m. of September 15, 2019, Police Senior Inspector Officer A of the Manila Police District Station received a text message from an unidentified civilian informer that one Mr. Z would be meeting up later that morning with two potential sellers of drugs at a nearby restaurant. As such, Officer A decided to hang around the said place immediately. At about 9:15 a.m., two male passengers named X and Y, who were each carrying a traveling bag, alighted from a bus in front of the restaurant. A transporter Barker, serving as a lookout for Officer A, signaled to the latter that X and Y were suspicious looking. As the two were about to enter the restaurant, Officer A stopped them and asked about the contents of their bags. Dissatisfied with their response that the bags contained only clothes, Officer A proceeded to search the bags and found packs of shabu therein. Thus, X and Y were arrested, and the drugs were seized from them. According to Officer A warrantless search was validly made pursuant to the stop and frisk rule. Hence, the consequent seizure of the drugs was likewise valid. What is the stop and frisk rule? Stop and frisk rule is a vernacular designation of the right of a police officer to stop a civilian on the street, interrogate him, and pat him for weapons. Was the stop and frisk rule validly invoked by Officer A? If not, what is the effect on the drugs seized as evidence? It was not valid. Stop and frisk serves a twofold interest. 1. Crime prevention and detection, and 2. Safety and self-preservation of the police officer. While probable cause is not required to conduct a stop and frisk, it nevertheless holds that mere suspicion or a hunch will not validate a stop and frisk. A genuine reason must exist, in light of the police officer's experience and surrounding conditions, to warrant the belief that the person has weapons concealed about him. Malacat versus CA. Q. A committee of the Senate invited Mr. X and Mr. Y, the Secretary of Foreign Affairs and Secretary of Energy, respectively, as resource speakers for an inquiry in aid of legislation. Mr. X refused to attend, arguing that the Senate, not its subcommittee, has the power to compel attendance. Meanwhile, Mr. Y attended the committee hearing, but upon being asked about discussion made during a closed-door cabinet meeting, he refused to answer, invoking executive privilege. The committee members insisted that Mr. Y answer the question pursuant to the right of Congress to information from the executive branch. Based on his argument, is Mr. X's non-appearance permissible? No. The Congress' power of inquiry includes the power to compel attendance not only by each House, Senate, and House of Representatives, but also by any of its respective committees. Is Mr. Y's refusal to answer based on executive privilege valid? No. If the officer wants to withhold an information on the ground that it is privileged, he must so assert it and state the reason therefor and why it must be respected. The mere claim of privilege without providing precise and certain reasons for the claim severely frustrates the power of inquiry of Congress. Senate versus Ermita. Q. The continuing threat to the security of the state in various parts of the country prompted the National Security Advisor of the President to adopt a comprehensive national security strategy, or CNSS, with the following components. Component 1. During a state of emergency, the President, in the exercise of his power of general supervision, may delegate to the heads of local government units, LGUs, through an administrative issuance, the power to call out the armed forces of the Philippines for a more effective and immediate response to the ground situation. And Component 2, in declaring martial law, the President, in a preemptive action and without waiting for the recommendation of the Secretary of National Defense and the AFP, may rely upon any intelligence information he may have gathered through other sources. Disturbed by the strategy's supposed infirmities, a concerned citizens organization raised the constitutionality of the two components of the CNSS before the Supreme Court. Is Component 1 of the CNSS constitutional? No. Only the President is authorized to exercise the calling out powers under Article 7, Section 18 of the Constitution. He is the only one who has full discretion to call the military when, in his judgment, it is necessary to do so in order to prevent or suppress lawless violence, invasion, or rebellion. Culayan versus Tan. Is component 2 of the CNS as constitutional? Yes. The President's power to declare martial law is not subject to any condition except for the two requirements of actual invasion or rebellion and that public safety requires it. It does not need the recommendation of the Defense Secretary in the AFP. Lugman versus Medial Dia. Q. Mayor X and his city administrator Y are political buddies who assumed their respective offices in 2010. Sometime in January 2012, Y proposed to Mayor X the entry into a 5 million loan agreement with ABC Foundation, a non-stock and non-profit organization in which the two had a long-standing personal involvement. The loan agreement was duly executed in the same year but was never authorized and approved by the Sangguniang Panlungsod. It was further found that the same constituted a fraudulent scheme to defraud the city government. Meanwhile, Mayor X won another term during the May 2013 election, and Y continued on as his city administrator. A year after, or in May 2014, administrative charges for grave misconduct, serious dishonesty, and conduct prejudicial to the best interests of the service were filed against them before the Office of the Ombudsman. In defense, Mayor X argued that his subsequent re-election in May 2013 absolved him from any administrative liability for any alleged anomalous activity during his first term in office. Y raised the same defense of condemnation having been retained by Mayor X as city administrator for a second term. On December 10, 2015, the Ombudsman rendered its ruling in the case, finding both Mayor X and Y administratively liable, citing the Supreme Court's decision in Carpio Morales versus Court of Appeals, which was initially promulgated on November 10, 2015. The Ombudsman rejected their defense of condemnation, with the motion for reconsideration of Mayor X and Y having been denied by the Ombudsman on March 10, 2016. They elevated the matter to the Court of Appeals. Did the Ombudsman err in not giving credence to the defense of condemnation as raised by Mayor X? Explain. Yes, the Ombudsman erred in its ruling. Although the Supreme Court in Carpio Morales versus CA, November 10, 2015, has abandoned the condemnation doctrine, the same, however, is prospective in effect. Hence, a public official can benefit from this doctrine if re-elected to the office before November 10, 2015 by the same body politic electing the person. How about Y? Can he validly invoke the condemnation doctrine to absolve him of the charges? No. The condemnation doctrine would not apply to appointed officials since, as to them, there is no sovereign will to disenfranchise. Q. The unabated rise of criminality and the reported identification of delinquent children loitering in the wee hours of the night prompted CDC to implement a curfew ordinance. Minors unaccompanied or unsupervised on the streets by their parents or guardians between 10 p.m. to 5 a.m. may be apprehended by law enforcers subject to certain exclusive exceptions. These exceptions are 1. Minors running lawful errands such as buying of medicine, using of telecommunications facilities for emergency purposes and the like. 2. Night school students, and 3. Minors working at night. Minors apprehended for violation of the curfew ordinance shall be required to undergo counseling accompanied by their parents or guardians. Does the curfew ordinance violate the primary right and duty of parents to rear their children? No, it does not. While parents have the primary role in child rearing, it should be stressed that when actions concerning the child have a relation to the public welfare or the well being of the child, the state may act to promote these legitimate interests. Thus, in cases in which harm to the physical or mental health of the child or to public safety, peace, order, or welfare is demonstrated, these legitimate state interests may override the parents' qualified right to control the upbringing of their children. As parents patriae, the state has the inherent right and duty to aid parents in the moral development of their children. Samahan ng mga progresibong kabataan, Spark versus Quezon City. Does the curfew ordinance infringe any of the minors' fundamental rights? Explain. No, it does not. The ordinance has passed the two prongs of the strict scrutiny test. One, the ordinance is necessary to achieve compelling state interest. That is, there is a compelling interest to promote juvenile safety and prevent juvenile crime in the concerned locality. And two, the least restrictive means to protect such interest or the means chosen is narrowly tailored to accomplish the interest. That is, the ordinance provides for adequate exceptions that enable minors to freely exercise their fundamental rights during the prescribed curfew hours and therefore narrowly drawn to achieve the state's purpose. Same case. Q. An information for estafa was filed against the accused, Mr. D. During the course of the trial, Mr. D filed a motion to dismiss for failure to prosecute the case for a reasonable length of time. Opposing the motion, the prosecution argued that its failure to present its witnesses was due to circumstances beyond its control. Eventually, the trial court dismissed the case with finality on the ground that Mr. D's right to speedy trial was violated. A month after, the same criminal case for estafa was refiled against Mr. D, prompting him to file a motion to dismiss invoking his right against double jeopardy. The prosecution opposed the motion, arguing that the first criminal case for estafa was dismissed with the express consent of the accused, as it was, in fact, upon his own motion. Moreover, it was already able to secure the commitments of its witnesses to appear. Hence, it would be prejudicial for the state if the case were to be dismissed without trial. For a double jeopardy to attach, what requisites must exist? To raise a defense of double jeopardy, three requisites must be present. 1. A first jeopardy must have attached prior to the second. Number 2. The first jeopardy must have been validly terminated. And 3. The second jeopardy must be for the same offense as that in the first. In relation to this, the first jeopardy attaches only upon a valid complaint or information. B. Before a competent court. C. After arraignment and a valid plea has been entered. And D. The accused was previously acquitted, convicted, or the case was dismissed or otherwise terminated without his express consent. Rule on Mr. D's present motion. The motion to dismiss of Mr. D should be granted. While it is true that the right against double jeopardy cannot be invoked if the dismissal of the original case was with the express consent of the accused, this rule, however, admits of two exceptions, namely insufficiency of evidence and denial of the right to speedy trial. Philippine Savings Bank versus Birmoy. Hence, Mr. D may invoke right against double jeopardy. Q. Attorney G ran for governor of the province of Pampanga, while his close friend, Attorney M, ran for mayor of the municipality of Guagua, Pampanga. They both won convincingly. Eventually, the losing candidates timely filed election protests. The losing gubernatorial candidate, Mr. A, filed his protest before the Regional Trial Court of Pampanga, RTC, whereas the losing mayoralty candidate, Mr. B, filed his protest before the Municipal Trial Court of Guagua, Pampanga. What are the term limits for the positions of Attorney G and Attorney M? The term of office of both positions in 3 years and for not more than 3 consecutive terms in the same position. Does the RTC have jurisdiction over the case filed by Mr. A? No, it is the COMELEC which has jurisdiction over election contests for any regional, provincial, or city official. Does the MTC have jurisdiction over the case filed by Mr. B? No, it is the RTC which has jurisdiction over election contests for municipal officials. Q. W. The incumbent congressman of the province of Albay decided to run for governor. He filed his certificate of candidacy for governor without resigning from his post and continued exercising his duties as congressman, such as attending plenary sessions and committee hearings in the House of Representatives. One of W's fiercest critics, X, claimed that W should not be dispensing the functions of a congressman since he is deemed ipso facto resigned as such upon his filing of a COC for governor of Albay. Is X's argument correct? No. If the person is holding an elective office, he shall not be considered ipso facto resigned from his office upon the filing of his certificate of candidacy for the same or any other elected office or position, and can still continue to hold the office. In fine, an elected official may run for another position without forfeiting his seat. Quinto versus Comelec. Assuming that W is instead an incumbent Undersecretary of the Department of National Defense, what is the effect of the filing of his COC for the position of governor of Albay to said posts? The effect is that he shall be considered ipso facto resigned from his office and must vacate the same at the start of the day of the filing of his certificate of candidacy. Who are the impeachable officers under the 1987 Constitution? Briefly explain the process of impeaching them thereunder. The President, the Vice President, the members of the Supreme Court, the members of the Constitutional Commissions, and the Ombudsman are the impeachable officers. The process of impeachment is laid down in Article 11, Section 3 of the Constitution. In summary, 1. A verified complaint for impeachment may be filed by any member of the House of Representatives or by any citizen upon a resolution or endorsement by any member thereof, which shall be included in the order of business within 10 session days and referred to the proper committee within 3 session days thereafter. The committee, after hearing and by a majority vote of all its members, shall submit its report to the House within 60 session days from such referral, together with the corresponding resolution. The resolution shall be calendared for consideration by the House within 10 session days from receipt thereof. Number 2. A vote of at least 1/3 of all the members of the House shall be necessary either to affirm a favorable resolution with the articles of impeachment of the committee or override its contrary resolution. The vote of each member shall be recorded. 3. In case the verified complaint or resolution of impeachment is filed by at least 1/3 of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. And 4th, the Senate shall have the sole power to try and decide all cases of impeachment. When sitting for the purpose, the senators shall be on oath or affirmation. When the President of the Philippines is on trial, the Chief Justice of the Supreme Court shall preside, but shall not vote. No person shall be convicted without the concurrence of 2/3 of all the members of the Senate. Q. A proposal to change a provision of the 1987 Constitution has been put forth as follows. Original text. The Philippines is a democratic and republican state. Sovereignty resides in the people, and all government authority emanates from them. Proposed text: the Philippines is a democratic and socialist state. Sovereignty resides in the party, and all government authority emanates from them. Is this an amendment or a revision? This is a revision. Using the qualitative test, the proposal will accomplish such far reaching changes in the nature of our basic governmental plan as to amount to a revision. A change in the nature of the basic governmental plan also includes changes that jeopardize the traditional form of government and the system of check and balances. Briefly explain the process to revise the 1987 Constitution. There are two basic steps in this process. One, proposal. A revision of the Constitution may be proposed by A. The Congress upon a vote of three-fourths of all its members, or B. A constitutional convention. The Congress may, by a vote of two-thirds of all its members, call a constitutional convention, or by a majority vote of all its members, submit to the electorate the question of calling such a convention, and number two, ratification. The revision shall be valid when ratified by a majority of the votes cast in a plebiscite, which shall be held not earlier than 60 days nor later than 90 days after the approval of such amendment or revision. Q. R was elected as municipal councilor for three consecutive terms. Before the end of the third term, Vice Mayor S died, rendering his post vacant. Since R was the highest ranking municipal councilor, he assumed the office of the Vice Mayor. One of his constituents, T, assailed R's assumption of office, arguing that elections should have been conducted to fill in the vacancy following the death of Vice Mayor S. Is T's contention correct? No, T's contention is incorrect. Under the rule on succession of elective officials, if a permanent vacancy occurs in the office of Vice Mayor, the highest ranking Sangguniang member, or in case of his permanent inability, the second highest ranking Sangguniang member shall become the Vice Mayor. Assuming that R validly assumed S post, at the end of R's terms as Vice Mayor, may he run once more for the position of municipal councilor, or is he proscribed to do so under the local government code? Yes, he may run again for the position of municipal councilor. The Supreme Court has held that if the official runs again for the same position he held prior to his assumption of the highest office, his succession to said position is by operation of law and is considered an involuntary severance or interruption. Q. Under the 1987 Constitution, to whom does each duty or power, privilege, prohibition, disqualification apply? A. The authority to keep the general accounts of the government, and for such period provided by law, preserve the vouchers and other supporting documents pertaining thereto. Answer to the Commission on Audit. The power to allow small-scale utilization of natural resources by Filipino citizens, as well as cooperative fish farming with priority to subsistence fishermen and fish workers in rivers, lakes, bays, and lagoons, to the Congress. The authority to provide for the standardization of compensation of government officials and employees, to the Congress. Under the 1987 Constitution, to whom does each duty, power, privilege, prohibition, disqualification apply? The sole power to declare the existence of a state of war, the Congress, by a vote of two-thirds of both houses in joint session assembled, voting separately, shall have the sole power to declare the existence of a state of war. The power to ratify treaties and international agreements, to the President. Q. Congress enacted an appropriation law containing a provision that gives individual legislators the discretion to determine post enactment how much funds would go to a specific project or beneficiary, which they themselves also determine. Consequently, disbursements were made in the interim pursuant thereto. Eventually, Mr. C filed a petition questioning the constitutionality of the statutory provision on the ground that it violates the separation of powers principle. On the other hand, certain congressmen argued that there was nothing wrong with the provision because, after all, the power to appropriate belongs to the Congress. Rule on the argument of the parties. Mr. C is correct. This is pork barrel system, which the Supreme Court has declared unconstitutional. It was held that insofar as it has allowed legislators to wield in varying gradations non-oversight post-enactment authority in vital areas of budget execution. The system has violated the principle of separation of powers. Also, the argument of these congressmen is misplaced because insofar as it has conferred unto legislators the power of appropriation by giving them proposal discretionary funds from which they were able to fund specific projects which they themselves determine, it has similarly violated the principle of non-delegability of legislative power. Belgica versus Ochoa. Assuming that the provision is declared unconstitutional, should the disbursement made pursuant thereto be returned in light of the doctrine of operative fact? It depends. If its unconstitutionality was declared before the promulgation of the decision in Belgica versus Ochoa on November 19, 2013, disbursements made pursuant thereto should not be returned, as the decision has expressly been treated with prospective effect in view of the operative fact doctrine. If, on the other hand, its unconstitutionality was declared on or after the said date, disbursements made pursuant to that law system should be returned because the pork barrel system's unconstitutionality applies to all other congressional pork barrel provisions similar thereto. Same case. Q. A was appointed by the President as the Commissioner of the Commission on Election, or COMELEC, while Congress was not in session. Pending confirmation of his appointment by the Commission on Appointments, A started to perform his official function in the COMELEC, such as attending en-banc sessions, hearing elections protests, signing resolutions, issuing order, the exercise of official function, a stating that his ad interim appointment is not a permanent appointment, but a temporary one pending confirmation by the Commission on Appointment, and thus prohibited under Article 9, letter C of the 1987 Constitution, which states that no case shall any member of the COMELEC be appointed or designated in a temporary or acting capacity. Is Attorney B's contention correct? No. Attorney B's contention is incorrect. An ad interim appointment is a permanent appointment because it takes effect immediately and can no longer be withdrawn by the President once the appointee has qualified into office. If the Commission on Appointments bypass the confirmation of A, can he still be reappointed by the President? Yes. Subsequent renewals by the President of ad interim appointment of commissioners of the COMELEC do not violate the constitutional provision prescribing their reappointment. Section 1, Number 2, Article 9-C. Because Commission on Appointments did not act on said appointments after submission by the President, an ad interim appointment that has lapsed by inaction of the Commission on Appointments does not constitute a term of office. The phrase without reappointment applies only to one who has been appointed by the President and confirmed by the Commission on Appointments, whether or not such person completes his term of office, there must be a confirmation by the Commission on Appointments of the previous appointment before the prohibition on reappointment can apply. Matibag versus Benipayo. Q. Candidate X, a naturalized Filipino citizen, ran for congressman for the lone district of Batanes. After a close electoral contest, he won by a slim margin of 500 votes. His sole opponent, Y, filed an election protest before the Commission on Election, COMELEC, claiming that X should be disqualified to run for said position because he is not a natural-born citizen. While the case was pending, X was proclaimed by the provincial election supervisor of Batanes as the duly elected congressman of the province, distinguished between natural-born and naturalized citizen under the 1987 Constitution. In general, natural-born citizens are those who are citizens of the Philippines from birth without having to perform any act to acquire or perfect their Philippine citizenship. As an exception, those born before January 17, 1973, of Filipino mothers who elect Philippine citizenship upon reaching the age of maturity are also natural born citizens, although they perform a certain act to perfect their Philippine citizenship. Naturalized citizens, on the other hand, are those who have undergone naturalization procedure in accordance with law. Simply put, all naturalized citizens have performed a certain act to acquire or perfect their Philippine citizenship, while some natural-born citizens have and some have not. Article 4, Section 2. Is X qualified to run for Congress? No. Candidate X is not qualified. Under the Constitution, no person shall be a member of the House of Representatives unless he is a natural-born citizen of the Philippines. Candidate X is a naturalized Filipino. Did X proclamation divest the COMELEC of its jurisdiction to decide the case and vest the House of Representatives Electoral Tribunal jurisdiction to hear the case? This question should be considered a bonus for having several errors, which would confuse the examinee. This is from Attorney Annan. First, an election protest or even co-warranto can be filed only after proclamation within 10 days therefrom. In the given set of facts, it was filed before proclamation. Second, ineligibility such as in citizenship is not a proper ground for an election protest. It is a ground for a petition for co-warranto or a petition for the denial of due course to or cancellation of certificate of candidacy. In the given set of facts, it states that the ground used for the election protest was because candidate X is not a natural-born Filipino citizen. Lastly, since the issue involves eligibility of a candidate and the case was filed before proclamation, the case must have referred to a petition for the denial of due course to or cancellation of COC. However, this is filed within 5 days from the last day for filing of COC, but not later than 25 days from the time of filing of the COC subject of the petition. In the given set of facts, it appears that the case was filed way after the prescribed period or after the election but before proclamation. If the case is an election protest filed within 10 days from proclamation, then there will be no issue and the COMELEC retains its jurisdiction until it decides the case. The same goes with petition for co-warranto. But if the case was filed for the denial of due course to or cancellation of COC, proclamation would ipso jure divest the COMELEC of its jurisdiction in favor of the House of Representatives Electoral Tribunal, provided the winner, aside from proclamation, has taken the proper oath and assumed the office. Otherwise, the COMELEC may still continue in hearing and deciding the case. Reyes versus COMELEC. H. a naturalized American citizen who later became a dual citizen under Republic Act 9225, the Citizenship Retention and Reacquisition Act, decided to run for Congress and thus filed a certificate of candidacy. A citizen argued that H is ineligible for the position because of his status as a dual citizen. H responded that his act of filing a COC amounted to his renunciation of foreign citizenship, rendering him eligible for the position. Was H filing of COC sufficient to renounce foreign citizenship? No. While the Supreme Court has previously declared that the filing by a person with dual citizenship of a certificate of candidacy is already considered a renunciation of foreign citizenship, such ruling was already adjudged superseded by the enactment of RA 9225 on August 29, 2003, which provides for the additional condition of a personal and sworn renunciation of foreign citizenship for those who desire to run for elective public office in the Philippines. Subojana, Condon versus Kamlek. Assuming that H is a dual citizen because his parents are Filipino citizens and he was born in California, was filing of a COC sufficient to renounce his foreign citizenship? This time the answer is yes. H dual citizenship is from birth without performing another act, such as swearing allegiance thereto, to be naturalized. The candidate who have Filipino parents became a citizen of the foreign state where he was born under the principle of jus soli and had not taken an oath of allegiance to said foreign state. A dual citizen from birth seeking public office in the Philippines does not need to execute a personal and sworn renunciation of foreign citizenship. His COC, which states that he renounces any and all foreign citizenship, suffices. Cardora versus Comlec. Hey, thank you for listening. If you're not yet subscribed, hit that subscribe button and let's study together. Thanks.